Good morning and welcome to the U.S. Commission on International Religious Freedoms hearing Laws Regulating Religion in Central Asia. I'm Vicki Hartzler, Chair of the Commission, and I want to thank our distinguished witnesses for taking the time to be here today and provide their testimonies on freedom of religion or belief in Central Asia. The U.S. Commission on International Religious Freedom, or USCIRF, is an independent, bipartisan U.S. legislative branch agency created by the 1998 International Religious Freedom Act, or IRFA. The Commission uses international standards to monitor religious freedom abroad and makes policy recommendations to the U.S. government. Today, USCIRF exercises its statutory authority under IRFA to convene this virtual hearing. Religious freedom conditions throughout Central Asia remain concerning. In June, I traveled to Kyrgyzstan with Vice Chair Asif Mahmoud and to Kazakhstan with Commissioner Mohammad El-Sanusi. During our visit, we saw firsthand the ways both governments violate the right of freedom of religion or belief. Authorities continue to employ a restrictive legislative framework, which includes laws on religion and extremism, to arbitrarily target the peaceful religious activities of minority groups and independent Muslims who deviate from the state's preferred interpretation of Islam. USCIRF regularly highlights similar trends in its reporting on Tajikistan, Turkmenistan, and Uzbekistan. In fact, each Central Asia state upholds similar laws on religion and extremism that reflect the legacy of the former Soviet Union, when religion was tightly controlled. The extent to which the governments of Central Asia enforce and interpret such legislation to violate freedom of religion or belief, however, varies. USCIRF recognizes this variation in its policy recommendations. For example, in USCIRF's 2025 annual report, we recommended that the U.S. Department of State continue to designate Tajikistan and Turkmenistan as countries of particular concern, or CPCs, for those governments' egregious, ongoing, and systematic violations of religious freedom. At the same time, we recommended Kazakhstan, Kyrgyzstan, and Uzbekistan be included on the State Department's special watch list for those governments' ongoing and systematic violations of religious freedom. This means that while USCIRF finds that the religious freedom violations in Kazakhstan, Kyrgyzstan, and Uzbekistan are severe, such violations do not rise to the same levels of severity as in Tajikistan and Turkmenistan. I would like to now turn the floor over to Vice Chair Asif Mahmoud to speak more about our recent trip to the region. Vice Chair Mahmoud.
Thank you very much, Chair Hartzler. I accompanied the chair to Bishkek, Kyrgyzstan in June, and the timing of this trip could not have been more important. Our delegation took place 6 months following the passage of a January 2025 package of amendments to the religion law and related legislation. The amendments marked the codification of a trend that USCIRF has been tracking for the last couple of years in Kyrgyzstan. The Kyrgyz government is increasingly scrutinizing the religious space. The amendments maintain a mandatory registration requirement for religious communities while creating further obstacles to obtain such registration. The law additionally invalidates the existence of independent Muslims in Kyrgyzstan, naming the Spiritual Administration of Muslims of Kyrgyzstan, a quasi-government body, as the religious authority of all Muslims in the country. In addition, the amendments ban facial coverings in public. In fact, we received reports that officials have already started fining women for wearing niqabs. In the wake of these changes to the legislative framework, we heard from a range of religious communities, members of civil society, and the Kyrgyz government during our delegation. While government officials argued that the legislative changes are necessary to combat extremism. Religious groups are apprehensive. Many expressed concerns that the new religion law is overboard and questioned how officials will interpret and apply its vaguely worded provisions. USCIRF also met with individuals who expressed that the new religion law favors groups considered traditional to Kyrgyzstan, including Sunni Muslims and under the Muftiyat and the Russian Orthodox Church. I will now return the floor to Chair Hartzler, who will speak about our delegation to Kazakhstan.
Thank you, Vice Chair Mahmood. I want to provide some input into our time in Kazakhstan before I introduce the witnesses. I appreciated the opportunity to lead a delegation to Astana and Almaty with Commissioner El Sanusi in June. Although I was encouraged by the January 2025 amendments to Kazakhstan's administrative code that reduced fines for those who violated the religion law, we found that religious freedom conditions largely remain stagnant. The law still provides the opportunity for authorities to penalize peaceful religious activities. The legal framework in Kazakhstan, particularly the religion and extremism laws, includes broad and vague provisions that provide authorities ample opportunity to target peaceful religious activities, which they do. Even once a religious organization is registered, the law requires government approval for all aspects of religious activities, such as holding events, maintaining places of worship, and distributing religious literature. As a result, authorities can arbitrarily decide which groups they will give permission to practice their faith, at times prosecuting peaceful minority groups for their religious activities, particularly newer Christian groups and independent Muslims. This legal frameworks allowed authorities in Jambol region to raid the religious services of independent Baptist churches in 2024. It allowed Kostani border guards to seize Christian religious literature that already had received a positive expert examination this year. Most disturbingly, the framework allows the government to continue to imprison 3 innocent Muslim men, Anatoly Zerenchenko, Ernei Samatov, and Beket Mibavyov, for their peaceful religious activities. Next, we will hear from U.S. Senator James Lankford of Oklahoma, who has been a leader of religious freedom in the United States Senate and who has provided video remarks for us today.
I'm United States Senator James Lankford from the great state of Oklahoma. Thank you to all of you that are so passionate about religious liberty and expanding the thought of protecting the rights of individuals to be able to believe or not believe as they choose to, no matter where they live. Our religious beliefs are literally our most sacred personal possession that we have in our soul. No government has the right to be able to step in and to be able to control what happens in our heart and in our soul. No government has that right. So thanks for the work that you continue to do to be able to press back on governments that are trying to literally oppress their own people and to be able to control their belief. Listen, I live in the state of Oklahoma. People cheer for University of Oklahoma football or Oklahoma State football or any number of teams around. We live next door to each other and cheer for different football teams, but we also live next door to each other. And some people are Christian, like I am. Some people are Muslim. Some people are Hindu. Some people are Buddhist. Some people are Jewish. Some people in my neighborhood have no faith at all. And we find a way to be able to work together. But for some reason, there are still nations and dictators and leaders around the world that believe that if everyone in the country doesn't believe like they do, it'll never work. Well, in the United States of America, we make it work every day. And we protect the rights of individuals to be able to have any faith of their choosing, change their faith, or to have no faith and still have a protected right to live free in America. That shouldn't be just an American value. That's a human dignity value. And it guards the rights of the individuals to be able to live their faith. So thank you again for what you do. Let's continue to be able to speak out because it is not so in many places around the world. And if it wasn't for people like you speaking out, that oppression would continue. But Thanks for calling people out, for identifying the challenges, and for holding people to that account until things get better for their nation and for their people. God bless you in the work.
Perfect. Well, thank you so much, Senator Langford. We really appreciate you as well as your entire team and all that you do for standing for religious freedom. And we appreciate your words today and taking time to make that video and send that message to us. Before we hear from our expert witnesses, I want to highlight that these freedom of religion and belief violations have a real human cost. One such person is freedom of religious and belief victim Pavel Schreider, who Kyrgyz authorities sentenced to 3 years of prison in July for his peaceful religious activities on falsified extremism charges. Of course, it's not just the individuals who suffer, but their family and their friends too. We met his daughter, Vera Schreider, on our country delegation, where she shared her father's heartbreaking story of religious persecution. And we think you should hear it too. So we invite you to go to our website, which is uscirf.gov, then go to the hearings section, and you can see her video there and watch her as she shares her story of what happened to her father and how it's impacted their family. So we encourage you to do that so you could hear from her directly. But now we're going to hear from our panel of expert witnesses. We have Professor Vanile Niailoin, Mr. John Kinahan, Ms. Indira Ajlanova, and Mr. Yevgeny Jovtis. So our first witness is Professor Vanile Niailoin, the former United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. So please proceed with your testimony, Professor Niailoin.
Thank you, everyone. I'm very pleased to be giving these remarks, and I do so in my personal capacity. They draw on my experience as an international lawyer whose specialty is international law and human rights, and are informed by my tenure as UN Special Rapporteur on Counterterrorism and Human Rights, a role in which I served from 2017 to 2023. In my scholarship and during my UN tenure, I was particularly concerned with the ways in which counterterrorism, security, and countering extremism laws and practices were deployed to undermine or negate fundamental rights, including the right to freedom of religion and belief. I encountered this challenge in multiple country visits, including in both Western and non-Western states. It was also true of the 2 country visits I conducted in Central Asia, namely to Kazakhstan and Uzbekistan. Today, I'm going to address the ways in which doctrines of security, counterterrorism, and extremism are used to undermine the right to freedom of religion and belief, including the right not to believe at all. In general, as I think many know, government approaches to preventing and countering violent extremism tend to state that religious or violent extremism is not exclusive to any region, nationality, or system of belief. But it is clear in implementation that many laws, programs, and policies have indiscriminately targeted certain groups and communities, particularly on religious grounds. And that has been thoroughly examined not only by the mandate I held, but by the UN Special Rapporteur on Freedom of Religion or Belief. In certain countries, the agenda for preventing and countering violent extremism is exclusively focused on violent Islamic extremism, ignoring other forms of extremism and leading to stigmatization and polarization. I've been particularly uneasy at theological criteria being used as a basis for charging, detaining, and convicting persons, and used as a stand-in for a broader and scientifically based understanding in the context of rehabilitation and reintegration of individuals. I've expressed my profound disquiet at legislation that criminalizes extremist thought, belief, and content or hate speech on the basis that it's a precursor to terrorism. Because often, in fact, what that is a placeholder for silencing non-established or minority religious groups or non-majority opinions. Current and former UN Special Procedure mandate holders, including myself, have consistently expressed concern about legislation that enables widespread use of detention and re-education as a method of preventing and countering violent extremism. In many countries, what we see is the use of hate speech against the very minority groups that those laws were designed to protect. So let me talk briefly about legislation. I'm particularly concerned about the lack of precise legal definitions of extremism and violent extremism and the widespread violations of human rights that produces. Violations of derogable and non-derogable rights are experienced particularly by religious groups, minority groups, and civil society. And I underscore that the target population is often much broader than the target population for counterterrorism measures, which means we have to be very, very focused on states who are overusing these kinds of laws. That category of extremist crimes is particularly vague and problematic. Absent any qualifier of violence, the term is broad, it's over vague, and it encroaches on human rights, including the right to freedom of religion and belief in fundamental ways. It's my view that extremism has no purchase. In fact, it has no definition in international law. And when it's operative as a legal standard, particularly a criminal standard, it's simply irreconcilable with the principle of legal certainty and therefore incompatible with the exercise of fundamental rights. Let me give you two country examples to this end. Kazakhstan, as many of you know, is a diverse multi-ethnic society with substantial human resources and capacity. And historically, religious pluralism was a hallmark of society, including long-standing tolerance for religious diversity. However, when I visited Kazakhstan in 2019, I found that significant aspects of the criminal law concerning terrorism and extremism were broad and vaguely defined, impinging directly on the fundamental right to religion and belief. And I was particularly concerned about the use of the term extremism in national law and under Article 174 of the Criminal Code in particular. Its use and application against minorities and civil society is of deep concerns. I concluded that the broad formulation of extremism and other similar language unduly restricts freedom of religion and belief, expression, assembly, and association, and must be revised. I was also deeply concerned about the double requirements under the law on religious activity and religious associations that required registration for religious organizations, and then extraordinary obligations to comply with theological criteria. Let me say some words briefly about my 2022 visit to Uzbekistan. This is a country experiencing substantial and positive political change. There have been reform efforts, primarily focused on social and economic issues, and there are structural changes in progress. Uzbekistan is elected to the Human Rights Council. It is playing an important role globally, but nonetheless, it continues to have legislation in the criminal law concerning terrorism and extremism that is broad and vaguely defined, and it impinges directly on fundamental rights, including the right to freedom of religion and belief. There's a fundamental need to revise the criminal code relating to extremism, terrorism, and national security to end this challenge. I would also underscore the concern about the law on religious freedom and associations, which entered into force in 2020, and the ongoing role of the Committee on Religious Affairs, and the need to ensure that work is human rights and international law compliant. Let me conclude by saying that domestic law in the region is significantly influenced by the legal code of the former Soviet Union, including in national security and extremism-related laws. These laws are not dropping out of the sky. They're coming from a very particular place and history. Moreover, I have expressed my concern about the role of the Shanghai Cooperation Organization in establishing these standards on extremism, common standards across the region that are of long-standing concern in respect of fundamental rights. Again, these influences are shaping the way in which the language of counterterrorism, extremism, and security has been consistently consistently used to undermine fundamental rights, including the right to freedom of belief. So there's an urgent need to address how more broadly and regionally these doctrines and practices of securitization continue to undermine the right to freedom of religion and belief. Thank you.
Thank you for your testimony, Professor Nye-Loing. Now we welcome John Kinahan, who is affiliated with the Regent's Park College at the University of Oxford. So please proceed with your testimony, Mr. Kinahan.
Thank you, Chair Hartzler, and thank you also to USCIRF for its work and for the invitation to testify. In thanking USCIRF, I would also like to thank my fellow witnesses for their work, as well as to thank FoRB 18 for its work documenting freedom of religion or belief or FoRB violations in the region. As we've already heard from Fionnuala Ní Uallainn, there are significant similarities in the restrictions all 5 Central Asian states place on the exercise of human rights, including FoRB. The similarities don't end there. As OSCE election observation missions have documented, the rulers who impose such restrictions are not in their positions as a result of free and fair elections on an even playing field. One of the other similarities is that the laws imposing FoRB restrictions are drafted in secret, often with significant input from secret police forces, with minimal to non-existent public consultation. Kyrgyzstan's latest highly restrictive religion law and associated new amending law in the area of religion are cases in point. The final texts, as signed on 21st of January this year, were not made public until after the 28th of January, and they came into force on the 1st of February. In all the Central Asian states, the basic approach is to make the exercise of human rights conditional upon state permission. All exercise of FoRB without state permission and registration is illegal, and the public expression of the majority faith Islam is under total state control. In Kazakhstan, this approach extends to dictating how Muslims should pray aloud. Similarly common to all Central Asian states is strict state censorship of all religious books and objects, including online materials. Other similarities in all 5 states include strict controls on religious education. In Kyrgyzstan, for example, all religious education, whether of children or adults, is banned unless it has State Commission for Religious Affairs permission. All the 5 Central Asian regimes are hostile to any independent activity by the people they rule, irrespective of the state of their relations with Russia and China. This intent of unaccountable rulers to permanently control all of society is also recognizable in Russia and China, and is perhaps the most significant factor shared in common amongst all these countries. Restrictions on the exercise of FoRB are marked by the absence of the rule of law, turning laws into tools to attack the freedom of all, not only the freedom of religious believers. This is, for example, seen in Kazakhstan's ban on released prisoners taking part in often unspecified social activity. This can include bans on visiting places of worship, including for those who have no religious belief, such as former prisoner of conscience Max Bukayev. After in 2021 completing a 5-year jail term to punish him for demonstrations against proposed land use changes that would allow the sale of farmland to foreigners, he was banned for 3 years from taking part in public activities, including, and I quote, membership and participation in the activity of social organizations, including political parties, religious organizations, public movements, professional unions, and self-regulating organizations founded on voluntary membership. In one recent case, a Muslim former prisoner was allowed after release to go to a mosque, provided they did not talk to anyone. However, the mosque's imam observed him talking with another Muslim, and the next day the secret police, quotes, asked me whether I have rectified my mistakes, how I pray the namaz, whether I'm in contact with other religious figures. He threatened to take me back to prison. As Yevgeny Zhovtis observed to FoRB 18, laws usually give no clarity, so determining what is included in such a ban is impossible. There is no principled determination and no foreseeability. Yet another similarity is the willingness of rulers to use violence against the people they rule, not only in large-scale national events, such as Kazakhstan's Bloody January in 2022, during which at least 263 people were killed and very many were tortured. In all the Central Asian states, people who have been arrested for exercising their FoRB without state permission have been tortured with, as is normal in all such torture cases, impunity for the perpetrators. One of the most recent cases has been Kyrgyzstan's repeated torture, including blows with an iron pipe and the use of a stun gun, of true and free Seventh-day Adventist Church pastor Pavel Schreider and another church member during interrogations. No officials have been brought to account for the November 2024 tortures. The church operates without seeking state registration, and it appears that officials have been seeking since 2021 to ban it for that reason. In March of this year, the church was banned as, quotes, extremist, and on 10th of July of this year, the 65-year-old pastor was, as Chair Hartzler referred to it, jailed for 3 years and ordered to be deported to Russia after his jail term. As Indira Aslanova commented to Forum 18 on the ban, this case demonstrates that a broad interpretation of extremism can result in holding groups accountable but have no connection to violent actions. Conflating such concepts, she said, undermines the effectiveness of measures to counter genuine threats of violent extremism. As an Uzbek human rights defender who wished to remain anonymous for fear of state reprisals commented about Uzbekistan's religion law, we need real reforms and freedoms, including freedom of religion and belief, if we do not want extremism. So perhaps the most dangerous similarity amongst the Central Asian states is that their apparently increasing suppression of human rights, including FoRB, facilitates the very violence that the regimes claim to oppose. Thank you for your attention, and I look forward to our discussion.
Thank you very much for your testimony, Mr. Kinahan. And now our next witness is one of the individuals that Mr. Kinahan just quoted from, and that is Indira Aslanova. She's a religious studies expert, and so we look forward to hearing from you. Thank you, Ms. Aslanova.
Thank you, Chair. Thank you, USCIRF, for the opportunity to testify. From the beginning, I just want to note that restrictions we see in Central Asia today are part of a longer trend. Less than a decade after the adoption of democratic religion law in 19th, policies began to shift. From the early 2000s onward, new laws and amendments steadily expanded state regulations of religion. And this just mentioned recent legislation in Kyrgyzstan also illustrates this direction. The law's new amendments all requires for all religious communities to register and re-register every 10 years and limit registration to a group of at least 500 citizens in one region. Just to compare that, before 2025, it was 200 citizens. And in 19th, it was 10. So the legislation prohibits individual religious teaching outside of recognized institutions, restricts missionary work and proselytism, and distribution of literature in public places, and the fines for wearing certain attire covering face in the public and state institutions. And as mentioned, the law on countering extremism activity contains broad definitions, such as incitements of religious discord that allow organizations to be warned or liquidated and individuals prosecuted. In practice, these rules are applied widely. For example, in 2023, 2 Slovak nuns attending Mass were fined for unauthorized missionary activity simply for reading from the Bible. The same year, Hare Krishna wedding rehearsal in Bishkek was raided, the host was fined, and the visas of Indian students cancelled. So what was intended as a private cultural and religious celebration were reclassified as an unlawful religious event. Jehovah's Witnesses have faced raids as well, with their Bibles and texts confiscated for the state expertise. And this system of compulsory state expertise deserves particular attention. It determines whether literature may circulate it and whether communities may register. Groups like Ahmadi Muslim and Tengris have repeatedly been denied registration because experts concluded that their activity could disturb public order. Courts also rely on experts' opinion to classify materials as extremist. And as a result, literature has been banned and believers penalized not for the violence, but for interpretation that authorities deemed offensive or destabilizing. Through this process, norms traditionally linked to the blasphemy, like criticism of religion or alternative interpretation or public touching, gender minority issues with religion have been folded into the definition of extremism. What might once have been considered as a theological disagreement is reframed as a threat to public security. And this has created an environment where peaceful acts such as sermons, discussions, or social media posts might be treated as extremist. Beyond specific laws, Kyrgyzstan approach to religion is shaped by the broader logic of securitization. Since late 19th, official concepts have described non-traditional or destructive religious movements as a threat. And this framing has justified greater surveillance control and has stigmatized minorities as non-traditional, while empowering dominant mainstream religious institutions. The effect is the narrowing the space for diversity, the stigmatization of ordinary believers by associating them with extremism, and the erosion of trust. This dynamic are visible in prosecution and imprisonment. As was mentioned before, the True and Free Adventist Reformed Church was banned as extremist, and the pastor Pavel Schrader arrested in 2025. Police seized thousands of books, including Bibles, and similarly, dozens of Muslim believers have been prosecuted for so-called extremist practice of Islam, with nearly all cases ending in conviction despite the absence of incitement to violence. Also, a couple years ago, there was attempts to ban Jehovah's Witnesses as an extremist organization, again based on the results of the expertise. And this restrictive trajectory observed in Kyrgyzstan is not an isolated case. Across Central Asia, governments have increasingly approached religion through the lens of security, often prioritizing state control and social order over individual freedoms. While there are variations in degree and implementation, the overall pattern demonstrates a regional trend of narrowing space for FoRB. There is a clear shift from the early years of independence, when pluralism was formally welcomed, toward an increasingly restrictive and securitized framework. In conclusion, it's important to note that international research has consistently found that excessive restrictions on religion, even when it's justified in terms of security, often produce unintended outcomes. Studies show that high level of regulations are associated with greater social tension, reduced trust in institutions, in some cases increase the risk of instability and conflict. From this perspective, the Kyrgyz case reflects a broader global pattern. Measures introduced in the name of so-called religious security may over time undermine the stability they are designed to protect. A constructive way forward, therefore, lies not in the tightening control, but in ensuring that regulation is balanced, transparent, and compatible with both rights commitments and long-term social cohesion. Thank you.
Ms. Oslanova, thank you very much for your testimony. Our final witness is Evgeny Zhovtis. He's an international human rights lawyer and chief expert or consultant and member of the board of the Kazakhstan International Bureau of Human Rights. So, Mr. Zhovtis, please proceed with your testimony.
Thank you very much. Dear members of the U.S. Commission on International Religious Freedom, thank you for the opportunity to speak at this hearing. Kazakhstan's legislation, as well as in other Central Asian countries, and especially law enforcement practice in the area of freedom of religion, largely do not comply with the international standards. They are based on the principles of presumption of guilt, subjectively interpreted ideological and political expediency, and discriminatory approach to regulating the activities of religious associations. They are permissive and restrictive in nature, impose many prohibitions and restrictions that do not fully or partially meet the criteria of admissibility of restrictions on human rights and freedoms formulated in international law, and do not comply with the principles of legal certainty and predictability. This is confirmed by the conclusions and recommendations of the UN Human Rights Council within the framework of the Universal Periodic Review, the UN Human Rights Committee in the concluding observations to the periodic reports on the implementation of obligations under Article 18 of ICCPR, in a number of views, ICCPR, in a number of views of the Human Rights Committee on individual complaints, in the decision of the UN Working Group on arbitrary detention in the case of 8 Muslims from Kazakhstan in 2021, in the reports of the UN Special Rapporteur on FoRB, the UN Special Rapporteur on the Rights to Freedom of Peaceful Assembly and Association, and the UN Special Rapporteur on Human Rights and Counterterrorism, who visited the region in a number of years. In Kazakhstan, starting with constitution, where there are no guarantees of freedom of religion and belief, and it is stated that the appointment of heads of religious associations by foreign religious centers is carried out only in agreement with the relevant state bodies, the civil code, where religious associations are for some reason singled out separately from public associations, the special law on religious activity and religious associations, and ending with the Code of Administrative Offenses and the Criminal Code, the legislation is clearly repressive in nature. In the law enforcement activities of law enforcement and national security agencies, religious associations are classified as sources of threats to national security. The activities of religious associations without registration are prohibited, and to register a local association, at least 50 members are required. A regional association, 2 or more regions, at least 500, and a national association, half or more regions, at least 5,000. At the same time, the local or regional status of a religious association means that it cannot operate in regions where it is not registered. The registration procedure is very complicated, bureaucratic, and requires a positive conclusion from a religious studies expert, which is conducted by experts under a special body, the Committee for Religious Affairs of the Ministry of Culture and Information. Therefore, it's very difficult to register a new religious association and almost impossible to register a religious association that professes other branches of Islam. In general, the distribution of religious literature and materials of religious content is prohibited without a positive conclusion from the same religious studies experts. There is a requirement to notify about holding religious events outside the religious buildings. At the same time, the notification procedure to be undergone for a religious association planning to hold such event is actually not such a notification procedure per se, but contains many conditions. An event may be even refused at all. Missionary activity without obtaining the appropriate permission from local authorities is prohibited. In addition, the authorities consider such activity to be breaches of religious associations operating outside the region where the association is registered. The state strictly controls the activities of non-traditional religions and religious movements. Law enforcement officers and special services conduct raids with seizure of legal literature. Believers are punished for violations with the large fines, confiscation and destruction of literature, and in many cases, criminal prosecutions and long prison terms. This is especially true for minority Muslims, and in the vast majority of cases, there is no evidence of violence or cause for violence. For this purpose, articles of the Code of Administrative Offenses and Criminal Code that do not comply with the principles of legal certainty and predictability are used. For example, Article 489, violation of the legislation of the Republic of Kazakhstan on public associations, as well as management, participation in the activities of public and religious association, not registered in the manner established by the legislation of the Republic of Kazakhstan financing their activities. I am citing the whole title. And Article 489, violation of the legislation of the Republic of Kazakhstan on religious activities and religious associations of the Code of Administrative Offenses. And already mentioned by my friend Callanan, Article 174, incitement of social, national, tribal, racial, class, or religious discord, or Article 405, organization participation in the activities of public or religious association or other organization after a court decision to prohibit their activities or liquidate them in connection with their implementation of extremism or terrorism. In many cases, the only evidence in such cases is the conclusions of a religious expert examination. This is a general overview of the legislation and law enforcement practice regarding freedom of religion in Kazakhstan. And I will echo my colleagues that we are dealing with the post-Soviet legislation in authoritarian political context. Thank you for your attention. I'm ready to answer your questions.
Thank you very much, Mr. Zhovkis. And now we'll move into the question portion of today's hearing. You have just mentioned something that I want to start off and ask about, Mr. Zhovkis. Several of you have mentioned that this is a Soviet-era legacy. And what we have noticed, or I've noticed in the 2 trips that I've taken to Kazakhstan and Kyrgyzstan, and then looking at these other laws, as you've noted in your testimony, they're all very, very similar. And I was wondering if you could give more background. I'd like to start with Mr. Kinahan, because you mentioned in your testimony about that these laws are made in the dead of night and secretly with secret police making those laws. Can you expound on that? Did the Soviet Union or current come up with this law and hand it to all these leaders and say, hey, you guys should pass these things, or how did this come about? Mr. Kinahan, and you unmute there.
Yes. Thank you, Chair Hartzler. So, I mean, the laws that we've all referred to are often not directly Soviet-era laws, but they have very definitely a Soviet-era heritage. This deep suspicion of everything, and I really do mean everything, that is not state-controlled. The unaccountability of rulers of society, to the people they rule. I mean, we're talking here about politicians who'd be genuinely shocked if they ever faced a free and fair election. The wish to control, the idea of having a particular state body specifically set up to control and to limit the exercise of religious freedom. All of that are direct hangovers from the Soviet era and from the Soviet experience, even if they've gone through various editions, as it were, since then.
Okay.
So let's take of Kyrgyzstan's new law, where the 2025 religion law that we've been talking about replaced the 2008 religion law and subsequent amendments to it. There have been various drafts, often compiled at the initiative of the president, with heavy involvement of both the secret police and of the then State Committee for Religious Affairs. There have been various drafts made. 2 drafts were made public in November 2024, but these were not the drafts that were originally passed. Where quite often when we hear about what goes on within the Central Asian states, then there are references to meetings of the president with senior secret police and Religious Affairs Committee officials, as well as Muslim leaders. And as has already been referred to, these Muslim leaders are not in any sense leaders that have been chosen by the Muslim community. They've been appointed by the state in yet another hangover from the Soviet experience thing.
Okay.
They will then go through drafts, often secret, or only rarely published on the so-called parliament's websites. If there are consultations, they will tend to be much more pro forma in that there'll be public hearings where even those who attend in good faith, wanting to see changes and that sort of thing, subsequently complain that they've been ignored, something. So, these are the kind of processes that go on in the drafting of such laws. And they're pretty typical for all of the Central Asian states, insofar as we know what is going on. And it should be stressed that they are often mild, out of public view.
Great. Well, thank you for those insights. I'd like to hear Professor Nieloing's comments on this too, and how they all are very similar and how this comes about. If you could succinctly kind of summarize your thoughts as well.
Sure. Thank you, Chair. I'd make a couple of remarks. I think the first is to acknowledge this legacy of securitization in the region, which has a strong Soviet dimension to it, and understanding that it sits heavily on the production of historic security laws, including but not limited to counterterrorism and countering violent extremism. The second is to say that we have another regional push, which is the regional push coming from the Shanghai Framework Agreement, led by China and other states, which again seeks to put in place common definitions and legislations and policies in relation to violent or extremism. Often, many of these laws do not have any qualifier of violence to the acts that are prohibited, and then directly touch on religious and other forms of expression. The third thing I would highlight, Chair, is I do think one thing to be aware of is that post the 9/11, the horror of 9/11, we've had a much bigger global framework of counterterrorism and countering violent extremism. And many states, through that process, whether it's UN Security Council Resolution 1373 or the Global Counterterrorism Strategy, are actively encouraged to pass legislation in these areas. And one thing I would underscore, Chair, is the extent to which these global strategies are largely human rights light or human rights free. So many countries, including Central Asian countries, are given positive affirmation. And I want to underscore this comes from the United States as well as by other countries in the region for their, quote, counterterrorism and countering violent extremism efforts. And one key thing for this committee to consider and reflect upon is the ways in which that broader affirmation has contributed to the production of these laws at the national level. And we need far more global reflection and leadership from the United States on ensuring that these global policies, whether enacted at the UN or bilaterally on extremism, including violent extremism, fully reflect human rights standards. They don't currently. So these states have sort of two options. They can go and be affirmed for their positive and muscular efforts in the area of counterterrorism and extremism, and they're not under pressure to enforce human rights standards in those domains. So I would stress the Soviet legacy. I would frame the contextual influence of the Shanghai Framework Agreement, but I would also just underscore that these states also get positive reinforcement for these kinds of laws through global counterterrorism and violent extremism strategies, where we need a much healthier and deeper impact of human rights norm on religious expression to be integrated into those standards. Thank you.
That is a really, really good point that I think we should take to heart and look at. I noticed Ms. Aslanova, you were nodding. Do you have anything you would like to add on this topic before I turn it over to the Vice Chair?
Yeah, I completely agree with this influence of the global policies into local and how it's let's say, localized or adapted, because if international laws or concepts speak about violent extremism, the local law is about extremism. And whenever grants are coming to counter violent extremism and terrorism, they use the local laws that countering just extremism and some non-traditional expressions, let's say. But also I would add to this that we shouldn't forget about the public demand of the mainstream in the countries. And here, by the Soviet legacy, I also want to say like that the Soviet approach or understanding of religion, meaning that it's not just about the laws, but about how the public or mainstream asking for these restrictions, which is quite interesting in terms of observing from the rural to the city levels, the different dynamics there. Thank you.
Yes, yes. Mr. Zovtes, did you want to weigh in on this topic quickly?
Yes, very briefly. I think we have to add two important factors when we are looking at the Soviet legacy. The first is that we are dealing with the post-Soviet elites which do not consider the society having any political subjectivity. It's typical Soviet-style perception of the state versus the people. And they are looking at any independent area, starting with the political opposition, independent media, human rights defenders, religious associations, as a threat. And they want to control this threat as much as possible. And number two is the institutions. When you're looking in the key institutions of the country, KGB Light, the current Committee on National Security, police, law enforcement in general, judiciary, and the prosecutor's offices, all these institutions are carrying Soviet legacy. They are typical, they have never been reformed. They were modernized in authoritarian way, but never have been reformed in a sense how they are keeping this Soviet-style institutional memory. And this is the important issues in the, let's say so, in the basis of all this repressive legislation.
That makes sense. Thank you very much for your insights. I'll now turn to Vice Chair Mahmood for his questions.
Thank you, Madam Chair, and thank you, everyone. It's really so insightful. So I'm going to continue on the same topic moving forward. I know that this is a major concern, that it's a Soviet legacy, and some of those traditions or rules are being applied or modified. And obviously, neighborhood plays a big role. And China seems to be having more influence in Central Asia now. And China itself is one of the biggest religious freedom and actually human rights freedom abuser itself, like what they're doing with the Uyghurs, what they're doing with the Buddhist community, what they're doing the Falun Gongas, and how Christians have to go in dark to practice their religion. Obviously, they are giving them the insight, and whatever they are going to practice, they are going to not be able to preach them anything different. My question is how much, and I'm going to broaden this thing a little bit more, how much it is this religious persecution, religious restrictions, and quietening in Central Asia is affecting when they see that West, especially United States, let Nigeria, a big ally, let Pakistan and India, big allies, continue do persecution of similar communities. The communities affected in Central Asia are minority Muslims and Christians, and a small group of Hindus or other Jehovah's Witnesses, which you take them in Christians. And does that embolden them that they can have the relationship with the United States and West, doing everything they are doing, when they have other allies doing the same thing? And what we should do at this time, because this registration law is really a very fundamental means to stop or mean to just quieten them even in the beginning. They cannot speak, they cannot talk, they cannot practice in their own religion. How they will be able to progress further? How they can bring more pastors from outside? What we should do, or what the United States should do, like 1, 2, 3 actions now urgently to make sure that we can open the window of religious freedom and belief in whole Central Asia, because Central Asia is really very important to our interests and for the rest of the world. And I'm opening this to everybody because I think everybody has a good insight about whole Central Asia. Um, I don't want to make one person and bring more questions because we are somewhat tight on the time. Thank you.
Why don't we just go in reverse order this time? Mr. Uzbekistan, would you like to go first?
Yes, thank you very much. First of all, I used to say that human rights, including freedom of religion and belief, in the modern world are the hostages of the geopolitical and internal political context. And if these contexts are moving in the wrong direction, the situation is worse and worse. I will give you a very simple example. If you look at the UN Human Rights Council, we have the North Korea, which reported 4 times successfully about the successes of human rights, and their reports were reviewed by the China, Cuba, and Sudan. I think that something is wrong with criteria. And of course, the rulers of the countries in the region, as well as the societies, will learn about the real politics. And we know very well what does it mean. That I think that the only way what to do to keep the human rights concept, the universality of human rights, and the bar of the human rights understanding on the as high level as possible, and not to play with the standards, with the allies or foes, because it does not work for the better future. Maybe in the short term, but not in long term.
Very good. Thank you. Ms. Oslanova? I believe you're muted. Thank you.
So for the urgent, I guess what is needed for now is to offer support or asylum pathways to members of the community at risk of persecution, such as mentioned Reform Adventists, because while the organization in the list of the extremists, it means that all followers are vulnerable and on the radar. For the also encourage maybe and funding for the civil society to document and monitor restrictions and its impact to the people, and build the capacity of the religious and not religious organization for this. So in terms of other bigger recommendations, I guess we have more experienced people here to say.
Thank you. Mr. Kinahan?
So I will be brief, firstly to say that I agree with everything my colleagues have said. I would make one point about the discourse around human rights and security, and that is to make the point that actually, if one really wishes to undercut the foundations of violent extremism, if one really wishes to address regional social tensions which can lead to violence, then human rights should be presented as the greatest friend of the relevant government. It's a more or less universal experience across the world, including in my country, Ireland, as also Fiona Newlands' country, that large-scale killings cannot be halted without there being effective human rights protection for everyone, or whoever may be the violator. And we should also recall that human rights suppression can, cause a long-term upsurge of anger. I can remember as a child in 1970s Dublin, the upsurge of anger after the infamous Bloody Sunday killings. And that is a universal human experience. And so I think in terms of what outside actors can do in engaging with Central Asian governments and indeed other governments is to point out to them that the suppression of human rights and the tolerance and impunity for killings and torture is not a consequence-free action. it will lead to consequences, even if they're not immediately obvious. And it will make addressing violent extremism, it will make addressing the ability of citizens of a society to express themselves vastly more difficult to address.
Very good. Thank you. Professor Nielon.
Thank you very much. I guess I would just have to the vice chair, I would say several things about what the consequences are when it is perceived or actual that we are selective in our criticism of states who fail to uphold their obligations to ensure religious freedom across several countries. And the first thing I would say to the United States is that it is particularly important that we are consistent. When we are not consistent, we create the basis for other states to say that we are selective, that these are not universal standards. And if we apply an a la carte menu to the states whom we criticize for their failure to uphold these absolutely fundamental rights, as the honorable member from Oklahoma pointed out, the freedom of religious belief is so fundamental to a person's human dignity and expression. But we can't decide that we criticize some and not others. And I think it's particularly incumbent on the United States to criticize our friends, because actually our friends are more likely to listen to us than those that we have disagreement with. And so it's particularly important whether we're talking about minorities, Christian minorities in Palestine, or whether we are talking about minorities in India, or whether we are talking about minorities in our European allies. It's absolutely incumbent on us to be consistent. Consistency is our friend. And the second point I would make is we have to remind states that we apply the law. And these states have all signed treaties, including the United States, which is a party to the Covenant on Civil and Political Rights. These treaties are unequivocal about the right to freedom of religion and belief. We go back to the Universal Declaration of 1948. Eleanor Roosevelt and others worked so hard to get a universal agreement that the right to freedom of religion and belief was the absolute foundation of the post-war human rights commitment of states. So states have agreed these standards themselves. They're not imposed from the outside. They're imposed by state agreement to be bound. So reminding states of those legal obligations consistently is critical. The third thing I would say, and I know the UN is not a popular body in many quarters, but I would underscore the central role that this body plays in upholding global standards on freedom of religion and belief. We don't have another global body to do that. I think this commission is enormously important, but it's a national commission. And unless we have global bodies entrusted to do this work, whose reach is to every country in the world, and support those bodies to do that work, we don't have global reach. And while there are weaknesses, I certainly wouldn't say there are not. It is the universality of this right that is the important and critical matter. And maybe finally, I would simply underscore the extent to which this emphasis that we have to ensure that security discourses and standards are not a rights-free zone, Chair, are incredibly important. So much of the work that's being done oppressively is being done through the cover of securitization. And security is a human right, but the right to abuse security is not. And so I think it's critically important that this commission play a leadership role in defining the relationship of security to the exercise of fundamental rights, including the right to freedom of religion and belief. Thank you.
Yes, thank you. Vice Chair Mahmood, do you have?
Yeah, if I can just follow up one brief question and then I'll give it to Chair. There's one unique feature in all these 5 states is repression and oppression of religious freedom. But one tool they use is registration, having different requirements in registration. What do you feel? How are they using them to reject people to be registered? Or if they are registered, how they are keeping much more close eye on them and monitoring them very closely and having them accountable. And the same thing, in the same context, you can also, if you have had any interaction with any of or all of those governments, about we have two nations who are hugely religious freedom violators. One is are abusers. One is Afghanistan, and second is Iran. And their particular focus is women, and they make women to put hijab or actually whole covering. Whereas in this case, we are going to the other extreme. We are punishing women who are even putting on a hijab. And where is the balance we can bring, and how we can help, and how we can challenge these things in both ways. So I'm combining both questions together so that we have a little time for Chair to further go on.
Sure. Yeah, is any particular witness like to respond to that? Okay, we'll start with Mr. Zhovtis.
One of the key problems with the registration is not the registration as such. This is a problem that the government in these countries, and in Kazakhstan in particular, they want to use registration as denying the right of individual for religion of belief. This is, they use the quantitative, let's say, characteristic. They said that you could believe, you could have the internal freedom, but you could not express your beliefs unless you do not get the governmental permission. And for this permission, it becomes the collective right. And you have 50 people and not less. If you have less, you could not be registered, and thus you could not profess your religion as it is written in the international law. And thus the registration is used for limiting this right to an absolutely narrow area.
Yeah, I will add, when we were in both countries, it seemed ironic, the government saying, well, you have to have 50 members or 500 members willing to register, but then yet you can't do any missionary activity, you can't distribute any religious literature, while you can't tell your children about your religion. I mean, we have to prove anything, and you know, so it's how are you supposed to share and grow your church, the number of people interested in your faith, if you can't do any of those things. So it seems to me like a backdoor way to deny anybody having the right to register, except for their preferred religions. But yeah, so
And also in several different regions.
that's right. You have to have so many members in different regions. So they put all these restrictions on it. And then they tell us, well, we have freedom of religion, see, but you just have to register. Yeah, but what is involved in that, right? So Ms. Azlovna, do you have anything you'd like to add?
Yeah, it's exactly why this contradictory provisions was added, like to limit this diversity, because for the minority groups, it's almost impossible to have, in Kyrgyzstan case, 500 followers from one region, right? And it's like Evgeny mentioned before, you can't do any activity, like external activity, if you are not registered. And plus here is limiting of the missionary activity, plus here this so-called religious expertise. So all this done to narrow space for the diversity, because diversity itself is the perception of the diversity as a part of the threat of the security, because diversity means there are diversity of the ideologies, ideology linked to the security. That's why there should be control. And all this, what is done, it's exactly for limiting. And all the discourse within the society was to form this concept that this is some foreign agents, I don't know, like this is the West, they're damaging the local traditions. The human rights itself and freedom of religion is a Western concept. And I just want to emphasize that the structural and direct violence couldn't happen without these cultural narratives that support this. that support that there are non-traditional groups, support that this is not like a local, that the local traditions are threatened through these religious groups. Yeah, thank you.
Very good. Professor Nia Loing, did you want to respond to the Vice Chair's questions?
Sure. Thank you, Vice Chair, and thank you, Chair. I guess I would just make two comments. One is that increasingly, I think, as a global matter, we are seeing the use of administrative measures as death by 1,000 cuts for non-established religions and for civil society as a whole. Historically, of course, we pay a lot of attention to things like the criminal law when people are imprisoned or deprived of their liberty or torture, and that's appropriate. But I do think that we can underappreciate the extent to which administrative measures function as a tool to essentially nullify the capacity of the right to emerge, meaning you can administer a right out of existence. And I do think that committees focus on the widespread use of administrative measures as a tool, registration among them, foreign agent laws, countering terrorism finance measures. There's a whole set of things, the size of the doorway into your building. Administrative measures can function as a way literally to make it impossible to exercise the right in any meaningful way. I would also just say to the Vice Chair, I think his clarion call to the extent to which women's rights are often the canary in the coal mine in relation to religious intolerance and religious freedom is prescient. The country of Afghanistan, whom we increasingly see as a state and a regime engaged in what we might term gender apartheid, demonstrates the extent to which, again, the nullification of women's rights is absolute. And I suppose I would just simply go back to basics, which is to say the UN Charter, the Universal Declaration on Human Rights, make clear that all women everywhere in the world have equality and autonomy. That autonomy includes the right to choose to be covered or not to be covered. That is at the heart of a person's right to make choice in their religious practice. But women are often the first port of call to restrict religious freedom. And I think the Vice Chair's assessment of that practice in reality points to the importance of observing women's rights as an entry point into understanding broader restrictions on not just women's rights and freedoms, but freedom of religion and belief also. Thank you.
Mr. Kinahan, did you want to add anything on this before we move on?
So just briefly, I want to underscore a way in which administrative measures are used to actually restrict the right. So typically, quite often, that registration applications need to be passed by some variety of local body or local authority. So for example, in the case of Uzbekistan, you can have mahalla or local district committees, which have the right to reject applications if the applicant is not perceived as quote unquote religious, with no definition of what religious means. They've often used excuses that, well, people in this neighborhood don't want to actually have this group here, even though they may actually be present, underscoring Indira's point about the way in which social attitudes can be used. We also shouldn't avoid talking about corruption, which is often where there are high levels of corruption in all the Central Asian states. And in some states, at least, certainly in Uzbekistan, there have been documented cases where it does appear as if, corruption is part of the issue. I'm aware that we are running out of time. So I want to pick up on the chair's point about women's clothing. Then, Tajikistan, has long attempted to target women who choose to dress as they choose, including wearing the hijab. The measures used can often be extremely violent. For example, in one case, if a woman chose to attend a concert in a park close to her home whilst wearing black dress to mark the death of one of her sons. She was detained, told that her dress does not suit the concert and the celebration. She can't enter. She tried to explain that she's in mourning. She was then arrested. She was tortured while being held overnight, and something, and so on. And we also have to not overlook the chilling effect that this has upon women who are aware of what happens with those who will go out wearing Islamic dress that they choose, where oftentimes they will feel under great pressure to stay at home rather than to go out to take part in society, to meet friends and so on. So, the targets are not only those women who are directly targeted, but they are also other women, within the state.
Great. Thank you. Thank you very much. I guess as we have about 15 minutes left, I want to make sure and ask this question. Where do you think the U.S. government can play the biggest role in the positive change in the region? Are there certain legal registrations and restrictions on religious freedom or for prisoners that the U.S. government should prioritize in its advocacy efforts? I mean, for example, could the U.S. government do a better job, raising FoRB issues in its C5+1 and other engagements? What specific things do you think the U.S. government should focus on in all of this? And I guess I'll go back into the original order of our speakers, Professor Nieloin.
Thank you, Chair. Look, I'm a person who fundamentally believes in the value of positive dialogue among states. I think that what we want to be doing is ensuring that there's constructive dialogue with these states. It's complicated to tell another government what to do, and that goes both ways. The United States doesn't like to be told the other way. I think we have to recognize that these are sovereign states, but they're sovereign states who have committed to fundamental human rights treaties and are bound by customary international law. So the first is the role of constructive dialogue. The second is to say that in that dialogue, much of which the most effective means of doing so is often ensuring that human rights gets raised at every single level of dialogue. Right. So I think one of the challenges we often face, particularly when governments may be using security and violent extremism as the entry point to the restriction of religious freedom rights, that the human rights people, maybe I would characterize all of the people in this call as human rights people, we're talking about human rights, but in security spaces, they're not talking about human rights. So I think what's particularly critical is ensuring that some of these concerns in our human rights spaces are actually flipping over and being found in engaged with seriously and consistently in those security spaces. That includes, of course, things like bilateral aid, security guarantees, and other things. Because if you keep human rights conversations to human rights spaces, we will never fundamentally change the dynamic of what's driving securitization conversations and securitization structures. The second broad area third broad area, and I'll close here, is that I would underscore the importance of US constructive engagement in multilateral fora on these issues. If the United States is not actively engaged on issues of religious freedom in the UN and in other spaces, that space will be filled by other states who do not have a constructive or positive view of the right to freedom of religion and belief. So it's incredibly important that the United States stay active, present, supportive of these multilateral spaces where these conversations happen and where accountability through UPR or other mechanisms occurs. If we're not in those spaces, I will guarantee you that they will be filled by countries like Russia and China, who will engage a very different dialogue with these states. So our consistent, active, positive presence in those spaces is absolute and much needed. Thanks so much.
Yes, thank you. Great words. Mr. Kinahan.
Thank you.
Yeah.
It's not really my role to offer advice to the US government on this, but I will underline what Fernand Mionen said about the importance of keeping the conversation going in both bilateral and multilateral fora. It is incredibly important to keep the conversation going across the board in all the topics raised. I should also say that I'd met quite a few US diplomats over the years engaged on these issues, and the US government does not lack for actively engaged, knowledgeable diplomats who are involved in and concerned about these issues. One thing that I would like to stress, though, is that it's important to challenge the discourse that somehow security, countering violence, countering terrorism, and human rights are two separate fora, are two separate bosoms which are somehow opposed to each other. They are not, because you can't hope to be able to challenge the conditions that lead to violent extremism, to challenge terrorism, to challenge large-scale rights violations without, there being constructive, strong protection for everybody's human rights. In that regard, it is always worth drawing attention to groups which may not have a very strong US presence, but are important within the countries concerned, such as independent Muslims in all the Central Asian states who choose to exercise their faith outside of state structures. It's important to convey the message that so far as outside actors are concerned, this is not a kind of a hostage question where the only groups who get focused on are those that have a presence within the foreign capital concerned. But this really is about universal rights for all people, and that all human rights are indeed connected.
Okay, that was great. Thank you very much. Indira Aslanova.
Yeah, what I want to say, it's pretty echo what colleagues just mentioned. And in terms of engaging in diplomatic or constructive dialogue, I just want to emphasize how sensitive it should be, because we had experience when the foreign agents law and when the state expressed its concerns, it had the opposite effect. Also demonstrating like that the country is independent and trying to be away from the Western influence. So just to understand that it also could have like a boss effect, and maybe go through the international institutions like UN, and raise the concern and or encourage Kyrgyzstan to bring its laws into the line with the international covenant, and also raise concern with regarding the cases of the prisoners of conscience. And again, what I think that is really needed for now is to provide this protection for the vulnerable communities, maybe asylum pathways to members, but also be inclusive in this way as well, like that they are representative of the different religious groups. And again, like the capacity building of the civil society and maybe the judicial actors, and as well as the state actors, in understanding how human rights could be protected at the same way with protecting the security, showing these pathways. And the last is, I still think that the public demand is something that should be the first, like this should be the internal initiative coming from the population, coming from the citizen, asking for the protection of their rights. Thank you.
Mr. Zoftis.
I'm in favor of dialogue, and I'm in favor of quiet diplomacy, but it should be meaningful and resultative diplomacy, not the diplomacy for diplomacy and the dialogue for dialogue. I understand that such authoritarian rulers, they do not like direct criticism and open criticism. For them, this quiet diplomacy, what they are very experienced in. But there should be again the result of such kind of diplomatic efforts. And if we are talking about the dialogue, it could be general dialogue or specific dialogue. When talking about general, I think there are some avenues for discussion. For example, to acknowledge the existence of the small religions which could live without registration, because in Kazakhstan a law which exists before the law of 2011, there was the provision about the small religions which do not need registration, and they could exist with the so-called only notification procedure. Second is what already Fionala said about extremism. I think that US should raise the issue of at least of let's assume changing the definition in Kazakh law from extremism to violent extremism. At least use the violent characteristic and the special characteristic. And finally, about the specific dialogue, it's about what already Indira said about the prisoners of conscience, about the religious groups which are banned or which are oppressed, to raise these issues and probably to ease the pressure. This probably will have some kind of positive impact. Thank you.
Very good. Well, we appreciate you all spending time today to share your expertise on this topic. Our heart is with the people of the Central Asia, and we're thankful they have the freedom that they do compared to a few years ago under Soviet rule. But it seems like they have a ways to go to truly having freedom of religion and belief, and there's some things that need to be changed there. So we will continue to advocate for those things, and I appreciate each of you in your role doing that too. I want to thank everyone who has watched today, and thank you for your interest in this topic. And this will conclude today's hearing. So thank you very much.